People v. Eric Sharp.
Good afternoon. May it please the court. My name's Dave Juergens. I'm from the Monroe County Public Defender's Office, and I represent Eric Sharp. If I could reserve 3 minutes for rebuttal.
Yes.
Mr. Sharp's requesting that this court grant a new trial because the trial court violated Mr. Sharp's statutory right to be present at a material stage of his trial. There was a Sandoval proceeding held in the judge's private chambers.
Why wasn't the colloquy with the defendant, when the defendant was present, sufficient to overcome? Let's assume for one moment, nobody's disputing, he's not present, that's an error. Why doesn't that cure that error? We've said one can.
It can if it constitutes a replication of what happened outside the defendant's presence.
Well, what does that mean? That the
That-
parties have to say exactly what they said in chambers, and the court has to say exactly what it said in chambers?
In sum and
Or outside the
substance,
presence of the defendant, excuse me?
in sum and substance, I believe the record has to reflect that the defendant was made aware of what the Sandoval colloquy was outside of his presence. Otherwise, he's denied an opportunity to meaningfully participate in the decision-making process that the court.
Well, let me ask you this. What if outside of the presence of the defendant, right, both lawyers say we stand on our submissions? Court says, okay, now there's another hearing, or, another appearance, and the defendant is present, and the judge says, does anyone want to add anything before I rule on the application? And both sides again say we stand on our submissions.
I don't believe that Sandoval requires that the attorneys necessarily argue differing positions, but I think this record supports a conclusion that there was discussion and there was argument in chambers on the Sandoval issues. We have 3 days before the proceeding, the court telling Mr. Sharp that we will have argument on the next court date regarding Sandoval. We have the attorney, after the Sandoval in chambers proceeding, stating in court that he spoke to Mr. Sharp, and he spoke to him yesterday and just now about waiving his right to a jury trial. That, by clear implication, means that he didn't discuss that issue in chambers, obviously, because Mr. Sharp was not there. And also, after the court placed its rulings on the record, the court said both parties have exceptions. So that only inference you can draw from that is that the parties each took opposing positions to the court's ultimate Sandoval rulings, and the
What do you say about the claim that, well, there's no formal rendering that took place until after?
I don't believe that it's a requirement that the court necessarily make its rulings at the proceeding where the defendant wasn't present, and then it's just a repetition in court. I mean, that may happen. We don't know on this record whether any rulings were made, but the important point is
His ability to contribute prior to an ultimate rendering of a decision.
That's exactly correct. He needs to be present for the Sandoval colloquy that constitutes the decision-making process. Merely putting the court's rulings on the record is just almost a legal matter. It's the court.
And here, his attorney, when the court did call upon counsel, he says, basically, I stand by what was previously discussed. But the problem with that is it was outside the defendant's presence, correct?
Correct. And I don't think there's anything in the record to support. The people strongly rely on the fact that they made a written submission, it was given to counsel. There's nothing in the record that a copy was given to Mr. Sharp, or that the content was ever shared with Mr. Sharp. And certainly as a lay defendant, when the court says Sandoval, there's no indication he understands what that involves, that it's a proceeding where the court's going to make a determination as to what prior bad acts or convictions can be used to impeach his credibility if he takes the stand. We, in this case, have a bare bones, we have one question, one sentence by the court, and then the rulings placed on the record. And this was not a situation where it was hybrid representation where, you know, the people seemed to suggest that he should have objected to the rulings at that point. Well, there's nothing, the court never addressed him directly. The court only asked the attorney, and there's no reason or indication as to why he should have spoke up in court at that particular time. He has, Doak's violations are based on the fact that the defendant has special knowledge of his own criminal history and that he could advance the defendant's position or counter the people's position if he's present to hear whatever discussion or arguments are had on the Sandoval rulings. And the rule in favor, if applied to this case, is that this record does not negate the possibility that the defendant may have made a meaningful contribution to the Sandoval colloquy had he been allowed to be present.
Could he have made a meaningful contribution on the second time as they're going through each of them?
Well, when they're going through each of them, that's the court already putting its decisions on the record. It's not a time when, because what the court didn't like in Doak's was that Sandoval rulings are made on the unrebutted submissions by the people. I mean, there should be an opportunity for the defendant who has this special knowledge to be able to correct errors, to give context to certain things. And there's 3 red flags in this record that I think raise concern. If you look at the record on page 72, this is item 4, it's the burglary conviction. The people in their submission say that the plea occurred on July 20th, 2009. If you look at the record at page 108, that's the second felony offender information on that same burglary conviction, they say the plea took place on November 18th, 2008. There's no explanation as to this discrepancy. A second red flag is there may be a cut and paste error in the people's written submission, because if you look at page 72 to 73, items 6 and 7 of the people's submission are identical, word for word. Misdemeanor convictions for criminal possession of controlled substance, same date. It looks like a cut and paste there. It's a red flag. And finally, 6 and 7 also involved misdemeanor pleas in county court. And that would be a rare occurrence if, and the only information we have is that it appears that he was indicted on a misdemeanor. Now, that can happen, but normally what happens is if evidence is presented to the grand jury and it's a misdemeanor, they send it back to the local court on a prosecutor's
Yeah, I mean, I
information.
agree with you on a lot of what you're saying, but the cut and paste issues, if the defendant had that motion 3 days before, that didn't take place at the discussion, I don't think, or I guess maybe that's the point. We don't know what took place.
We don't know what happened at the discussion. We don't know if Mr. Sharp was ever, whether, you know, there was ever any review by him of this submission.
And what if there was no discussion? What if the judge just decided to go through it, said, look, I think the judge said, I have these papers, I just saw it for the first time myself, we're going to argue it on Thursday. And then on Thursday, we have what happened. Maybe that was that entailed the entire thing, discussion plus decision, you know?
Well, I think the record refutes that in that it's clear from what the attorney said, it's clear from the court giving both sides exceptions to the ultimate ruling, that there was something discussed, argued, whatever it was, that we don't know.
Right.
And the reason you point out the potential red flags is that if he were present, then there could have been appropriate discussion with respect to those particular issues.
Absolutely. And there may have been other things that the defendant may have become aware of had he been present for the Sandoval colloquy.
But isn't the reference to the exceptions somewhat obvious? Defendant is not able to keep the people from referring to these past acts, and the people aren't getting everything they want. Isn't that the exceptions?
Well, the court makes a ruling weighing the
Right.
probative value against
Right.
the unfair risk of unfair prejudice. And when we look at the prejudice, we're also concerned with whether the adverse rulings are going to deter the defendant from testifying. And if he doesn't testify, then that's depriving the fact finder of material evidence.
No, I'm just referring, I thought it was a good point you made, that there must have been something that went on outside the presence of the defendant, because the court says both sides have exceptions, and I'm just saying, isn't it obvious the exception means the ruling is not giving everything each side independently wants?
That's true, and that happens frequently. But I think, the broader point would be that there was discourse, there was argument, or at least the sides adopting opposing positions, and the court ultimately made rulings, and
Well, counsel refers to what went on. I mean, counsel says, I stand by what I've already said.
True, and that's why I think it's very fair to read this record as that the in-chambers was a Sandoval proceeding. And the people don't contest that he wasn't present, so I won't go into the record as to what also supports that. The dissent, I think, in this case, Justice Curran, I think he got it right. He relied upon case law from this court, Monclavo and Smith, where there was there was argument, and there was stuff done in court in the defendant's presence that then would qualify as a de novo proceeding. We just don't have that here. This is as a matter of law, this was not a de novo proceeding. Turning just briefly to point 2, I would note that we've had a new development. Our primary concern with point 2 is that Mr. Sharp didn't have his right to one appellate review of the facts. He identified my red light's on. I don't know if I should address this.
You'll have your rebuttal, right?
Thank you.
Good afternoon, Your Honors. May it please the Court. Lisa Gray on behalf of the people of the state of New York. Here, the defendant was afforded meaningful opportunity, and those are the key words. He was afforded meaningful opportunity to participate during the court's subsequent de novo hearing, which cured his absence
What
from the initial
establishes
in-chambers
here
conference.
that there was, in fact, a de novo hearing that took place?
I think there's 4 things. The first thing is that there was the written applications that people filed a week before the on the record de novo hearing. And we know from the record that counsel had received a copy of that application. The court makes note of it on the record. Mr. Sharp is present there. So we know for a fact that counsel has this application and defendant is aware of it. The second thing is that when all the parties appeared back on the record on May 25th, the court invited further comment from counsel. Okay, we're back here now, we're on the record. Is there anything, Mr.
Right,
Trent's
and he
attorney?
says, I stand by what I argued before, but the problem with that is defendant wasn't present to participate in that portion.
He wasn't, but we do know that, again, the written application laid out very particularly the 8 items that the people were going to seek to cross-examine Mr. Sharp on should he take the stand. It was delineated by the type of conviction, the date, and given brief
So you're
underlying
saying the
facts.
written application somehow supplements what did or did not happen after the fact?
I think it does. I think it supplements it, and it goes to show the fact that,
Well, then, does this colloquy even matter?
sorry, Judge.
Does this colloquy even matter? It sounds like your position is as long as he is aware that there are papers submitted by the prosecution, he could have read it, he could have looked at it, and that's it. You don't even need this colloquy.
I don't know that you necessarily, well, You don't necessarily need it, because the standard is whether or not there was a meaningful opportunity for the defendant to participate in the colloquy if he wanted to.
Doesn't this create a situation where then it's easy to just cut the defendant out of it on a routine basis?
No, I don't think so, because the defendant is going to be present in court, which leads me to my third point. The third thing in the record that you should look at was, in addition to inviting the counsel for further comment, which he declined, then the judge uses anticipatory language. Okay, at this point, I'm going to make my ruling. Molyneux, he denies Molyneux. He says, now turning my attention, or everyone's attention now, to.
But haven't we said that that's not enough? Like in Monclova, we're saying there needs to be a discussion. And the record seems to indicate there was a discussion, and the problem is the defendant wasn't present. So at this second time, there is no legal discussion. There's just a recitation of the judge's ruling, and we've said that that's not appropriate.
I don't think, I think these facts are actually, I think, different from Monclavo. And I was reading Monclavo a few times, obviously, because some of the language is similar, right, between what the judge in Monclavo says and what occurred here in this case. But I think the biggest difference, and although some of the language mirrors each other, I think the biggest difference in Monclavo is the fact that the decision had already been made outside of the defendant's presence. So when they all come back on the record, and, you know, there's the colloquy that's attached to the opinion, you can tell that all the parties come back on the record, and everyone is trying to, there's some conflict or there's some discrepancy over what the ruling was, and the judge has to clarify it and says, that's going to be my ruling. So I think that's the big difference. Here, there doesn't seem to be any indication that
Yeah, but I think
That
that's
there
the
was a decision
problem,
made
right?
in
Like, there doesn't
chambers.
seem to be any indication. We shouldn't be in a position where we're speculating what did or didn't happen outside the presence of the
I
defendant.
actually read the sort of the opposite way of what you're, the opposite inference from it, that is, in comparing those two cases, right? There was some disagreement in Monclavo about what the rulings actually were. Here, it seems like everybody understood what the rulings were, what the exceptions were, and all the judge did was recite them. It seems like it was clearer here about that there was a definitive result in Chambers, and there no.
I don't think in this case that the judge's ruling was made in Chambers. When they all meet back on the record on May 25th, he says, okay, this is going to be my ruling, and he goes through each of the items, and he explains why he's making that particular ruling, whether or not it was moot, whether or not it was a violation.
That's ignoring that prior to the judge saying that, there are things that actually took place. And there are a number of instances wherein there can be discussion in different types of proceedings, be they civil or criminal, and then there's an opportunity for a formal record to be established. However, in a criminal proceeding, with respect to the defendant's right to be present at all material stages, question is, did he have that opportunity here, or did the court simply, by saying, is there anything you want to say? The attorney said, I stand by what happened before. Problem again, as my colleagues have also so stated, defendant wasn't present before. So it's not clear he had the ability to participate in then what ultimately the court then put forth on the record.
I mean, I guess I go back to the fact that there was the written application, and if you even go a little bit farther back in the record, during the pendency of the litigation, I think there's probably about 4 separate points, or 4 separate appearances where there is discussion of, as the case is heading towards trial.
Do you advocate this just being a written application and everybody responds in writing?
No, because obviously the defendant has salient facts that might contribute to how the decision ultimately is going to shake out. And there's also nothing to say that the defendant wasn't actively contributing to that discussion with his counsel, based on what he knew from the written application.
But isn't that the problem? There's nothing to say that he wasn't?
Except in this case, there was still that opportunity to be heard. Anything else you want to say?
Because he's in the courtroom.
Sorry, Judge, yes.
No, because he's in the courtroom when the judge says, okay, counsel, is there anything you wish to add? And now goes through the rendition of the judge's rulings, is that Why?
Yes, he is standing right there. And if you look at the record, this was not,
So how would he, let's go with that. Well, how would he participate? What,
he could,
he has not heard whatever the prosecution may or may not have said. He's not heard whatever the judge may or may not have said. He hasn't been in the room when his lawyer spoke.
Mr. Sharp certainly was active in his own defense, and that's apparent from the record. He certainly piped up on the record even before we get to the
No, I'm
Sandoval
not saying he
hearing.
doesn't have the ability to do so. I'm saying, what would it be based on, since he wasn't in the room?
He could have said, I never received this, what is anybody talking about? I have no idea what anybody's talking about. And he never said that. He could have said,
Have we placed that burden on the defendant? Have we said in the past that once there's been an error, the next time you're in before the judge, you have to say, by the way, I don't know what you all decided, I don't know what happened here?
ultimately goes back to whether or not he had the meaningful opportunity. And if he's standing there in the courtroom and has never heard of anything that's going on, at that point, he's next to his counsel, they're on the record, he could have said something. He certainly had no problem speaking up on previous issues. So again, based on this
Okay, let's
record-
say there had been a colloquy, defendant, hypothetical. Defendant is not present. The next time the defendant is present, and the judge issues a ruling, doesn't ask, does anybody want to, just issues the ruling, and defendant says nothing. Under your analysis, they had a fair opportunity to participate?
I think under that hypothetical, the court never invited further comment.
So that's the difference?
Correct.
Okay, but here, the judge only spoke to counsel, didn't ask the defendant if he had any comment. Does that matter?
The defendant was present at the material stage of the proceeding, which was the Sandoval
Yes.
hearing. It was a
Yes.
de novo hearing.
Yes,
The court invited further comment from counsel.
from counsel, yes.
And that meets the standard for the meaningful opportunity.
But isn't the understanding that a defendant can't directly communicate to the court, must communicate through judges? I've read enough records where the judge admonishes a party for speaking directly to them when they have a lawyer.
Well, then I suppose you're looking at whether or not there should be some sort of waiver.
I'm going to grant
of
you
this.
that if the judge actually did turn to the defendant and say, sir, is there anything you wish to add, comment on, question, maybe it's a different case. Sure, that's not this case.
No, but I go back to the fact that there was a written application that
Okay.
that counsel had in his possession at least 3 days before. This was a defendant who was actively participating in his own defense. And when everyone gets back on the record on the 25th, the trial court does invite further comment from the parties, and counsel doesn't have to, there's no requirement that everyone has to do a cold recitation of all the arguments that were made in chambers.
There's
back on
nothing.
the record.
There's nothing that's recited, right? I mean, this is
recited.
not a question where of, a very specific detail not being reiterated, it seems to me.
I mean, I think this case is akin more to Smith, and this court characterized what happened in Smith as, a preparatory bench conference. So everyone's on the record, at some point, there's a bench conference, they all come back on, and I think there's 4 outstanding items that the court gives a de novo decision on. And in this case, the Chambers Conference sort of acted as sort of as a preparatory conference. Housekeeping matters were discussed. There was seemingly a discussion about the Sandoval. When everyone comes back on the record on the 25th, again, the court says, anything else you want to add? And that together with that written application, with the fact that the court is going to uses the anticipatory language of, okay, now I'm going to give you my ruling, I think all of those things together amount to the meaningful opportunity, which counsel declined. I just want to move briefly to issue 2 that counsel brought up at the tail end of his argument, and that is, that, the missing evidence was not needed to resolve any of the issues raised on appeal. The appellate division properly ruled that the issues that were raised on appeal were able to be determined without the trial exhibits that had ultimately had been unable to be located. Defendant failed to identify how the missing trial exhibits might have contributed to any existing error, which he alleges prevents him from mounting an effective appellate review. I think.
But isn't it a case of he doesn't know what he doesn't know? I mean, maybe they would have viewed the evidence and come up with an argument.
Well, he could have raised a legal sufficiency argument or a weight of the evidence argument, and he did none of those things without pointing to some issue and saying, by not having these trial exhibits, it's germane to this other, standalone issue. It sort of foreclosed any sort of ability for the people to counteract that argument. There was never a motion to reconstruct the record or to reconstruct the exhibits. And so I think I would urge this court to look specifically and follow the reasoning in, I'm probably going to get the name wrong, but Yavru Sukuk, which I believe is what the appellate division cited in denying this claim. And so if there are any other questions, I would ask this court to affirm the appellate
Can I
division's
just
holding.
ask you, I'll ask him too, or he can say something different. Since the video has been found, what, if anything, can they do with that now? Can they go back to the appellate division and ask for a re-argument? I mean, we're on appeal here. What, if anything, can they do?
It was such an odd set of circumstances, and I think at this point, I don't know that a motion to re-argue would be appropriate. I don't know, perhaps if there a quorum nobis
Okay.
that might be an appropriate, procedural mechanism. I'm not exactly sure, but we wanted to make this court aware that the trial exhibits were actually located. And so, unless there are any other questions, thank you.
Thank you.
Regarding point 2, Mr. Sharp had an absolute right to one appellate review of the facts. When the people lost the exhibit and the record was stipulated that these exhibits are lost, he identified to the appellate division the issue that he could no longer raise, that was no longer viable. And the appellate division misread this court's decision in Yavru Sukuk to mean that if you don't raise a standalone issue that you really can't raise anymore because it's non-viable, because key evidence was lost, that we're not going to look at the facts. And I just think the appellate division's rationale on that was wrong. So we're hoping that the court grants relief under point 1, then you won't have to address point 2. Point 2, we ask for the same relief, a new trial. If the court wishes to review the record that it has before it, I think you could grant a new trial on point 2. If the court's reluctant to do that in light of the discovery of the missing surveillance tapes, the court might consider doing what this court did in Yavru Sukuk, is remitting it to the appellate term on a different issue, because the appellate term, the remittal to the appellate term in that case was to determine if appellate review was still possible without this lost audio tape. Here, the issue would really be, can the appellate division now conduct a weight of the evidence review now that we've found the lost video? And I'd have to concede that the answer is probably yes. So at a minimum, if we don't get relief on the first 2 grounds.
Even though you never raised that issue?
Pardon?
Even though you didn't raise that issue the first time around?
And I would have to ask the court to conclude that we didn't raise it because we couldn't, because the key evidence that we couldn't raise it because our whole argument that the verdict was against the weight of the evidence was based on the surveillance videos undercutting the credibility of the people's one witness in this case. And because we didn't have that, we were hamstrung, and it would have been almost a frivolous issue to raise because we didn't have what we needed. So, but if the court does consider remittal, I would think that there should be two directives. One, that there's an order that the record be reconstructed or supplemented, and I don't doubt that it would be supplemented by stipulation. And the second directive would be that the court order rebriefing on the weight of the evidence. Unless there's any other questions, I'll rest.
Thank you.